Watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. A very important message for all you folks out there. And hello and welcome, everybody. I am Nipasa Pradhan. This is Immigration and Jobs Talk Show. And thank you so much for tuning in. So, wherever you have joined us from, Facebook, LinkedIn, Twitter, which is now X, YouTube. Thank you so much. Really a heartfelt welcome to each and every one of you for joining this webinar. And I'm absolutely thrilled to have with us a very special guest, a familiar face, I would say. I mean, we had a webinar with him before the lottery, I would say. So yes, help me welcome back none other than Attorney Prashant Dubey. Yes, how are you doing?
I'm doing well, Nipasa. Thank you for hosting me again. It's always exciting to be back on the show, share some insights, share our thoughts, especially as it relates to the H1B process this time, and what a relevant topic given the fact that lottery selection notices are coming out this week. So it's an exciting time within the H1B world.
Absolutely. And folks out there, if you are an immigration enthusiast or someone who's navigating these intricacies, especially with the H1B, well, you're in the right place today. And we are going to have none other than Prashant Dubey. He is a very highly respected immigration attorney. He has been practicing for over 5 years now and based out of Washington, D.C., right? Prashant, tell us more about yourself for folks out there who have just joined us for the first time and meeting you, watching you for the first time.
Perfect. Yeah. No, if you haven't joined the other 9 webinars we've done together, I am Prashant Dubey. I am an immigration attorney based out of Washington, D.C. I've been in DC for over a decade now. And my primary areas of practice are family-based immigration, employment-based immigration, right? H1B, perm applications, L1 applications, that sort of thing. And then we also do immigration litigation. So for anybody's processes or immigration petitions that might be stuck or you might be out of processing time, we love filing lawsuits against USCIS to get you unstuck and get your approvals back. And we've done a lot of that for individuals within, the H4 EAD realm, anyone facing visa delays, green card application delays. So thank you again for having me on the show.
Thank you, Prashant. It is always a pleasure to have you with us. And I am very sure that it's going to be a very informative webinar today as well. And our topic for today, friends out there, is Master the post lottery H1B process, expert insights and guidance. So it's going to be a good one today. So, Prashant, I mean, you were not there pretty busy, I'm sure, with so much work in your plate since the lottery started. So tell us what has been happening with you.
Yeah, no, so it's a very exciting time, right? So the lottery registration opened up in the first week of March. We've had petitioners and clients who've been reaching out to us to, file for the lottery registration system for their beneficiaries. This year, USCIS added some nuances to the online lottery selection process in that they created what's called organizational accounts. And
Mhm.
basically, organizational accounts are just a place where, an attorney's client or the petitioner, and anyone that that petitioner designates as an administrator to the account can really go online and collaborate to submit these registrations. So there were some additional steps that maybe weren't there before, but very administrative in nature, nothing crazy. And then, as USCIS usually does, there was a little bit of an extension period into the 25th. So just this past Monday, until which lottery registrations could have been submitted until noon Eastern on Monday. And then starting, I believe it was yesterday, folks and ourselves here, we've been getting selection notices for beneficiaries. So USCIS had a very quick turnaround, which means, basically at this point, the the thick of the H1B season is upon us, and we have between April 1st and June 30th to start submitting H1B applications. So the next 3 months are going to be busy. There's going to be a lot of work, but that's always a good thing.
It is, it is. And let's stay hopeful, folks out there. And without further ado, let's dive into today's topic. And Prashant, what immediate actions must H1B lottery winners undertake right after the lottery results are out? I mean, it's already started to be out. Is it over? I mean, all the results out by now, you think?
No, so I think USCIS, they've made their selections, but they are rolling out the results kind of day over day. So I think over the next few days into this weekend, perhaps even into Monday, we're going to start seeing those lottery selection emails start hitting our inboxes more and more. And so essentially, once that happens, right, you're essentially just waiting for the notification from USCIS. So once the lottery's been conducted, USCIS is going to email employers. They're going to email attorneys if you had an attorney submit the registration, and it will the selection notice is going to be in your USCIS online account, right? Once you're able to pull that, the immediate next step, right, is not necessarily going right into the thick of the LCA or the labor condition application or the I-129 application, but it's to sit down with, my client and talk through, okay, what are all the documents we need to collect? For example, from the beneficiary, we're going to need copies of their passports. We're going to need, resume, education documents and evaluations. We're going to need an end client letter or a vendor letter, right? Especially if somebody's being placed at a third party work location. We're going to need details of the job offer. We're going to have to get, the documentation related to the job duties, right? So those are all part of that initial process after somebody's been selected from the lottery, right? Is gathering all that documentation. And then once you have that, right, and you've made a determination that the petitioner is moving forward with the H1B filing, you want to file what's called the LCA, the labor condition application, right? And the labor condition application is, very simply a document that's filed online on the Department of Labor's flag website, which says, for the job that this individual is going to do, right, and the location that they're going to do it, what is the prevailing wage? Whether you're sponsoring them at a level one, level two, level three, level four wage, whatever that might be, the LCA will give you that wage rate, and you have to pay them at least that wage for the job that's going to be done in that specific location. And once you have the LCA, typically takes about 5 to 7 days to get that back. You can start preparing the I-129 application, which is for the H1B. If you do premium processing, then you're going to send along with it the 907 application, right? But essentially, once the I-129 is prepared and you've got all the supporting documents to go along with it, you simply file it with USCIS. If it's done in premium processing, you will get a receipt notice for both your I-129 and your I-907 premium processing receipt notice. And if absent an RFE, you should have a decision within 15 days. You can track the status of your application online on USCIS's case status online tool. Um, and let's say you do get approved. Once you're approved, if you're abroad, you're going to need to file a DS-160 application to schedule your visa interview in order to get your H-1B visa stamped to come to the US. If you're in the US, let's say within an F1 status, right now, and you're going to do a change of status from F1 to H1B, if your STEM EAD card, your OPT extension, if that's ending during this time, then you want to apply with what's called a cap gap extension that allows you to work until your H1B goes into effect, which is going to happen on October 1st. So there's no, if you're within the US doing a change of status by way of this lottery, you don't need to go to a visa interview, right? You don't need to leave the country to activate your H1B. The change of status will be enough to activate it. And if you ever travel in the future and you don't have an H1B visa stamp, then at that time, you will need to get one, by filling out the DS-160 and doing that entire process for the visa stamp to come back. So from a very high level, right, those are the immediate next steps over the next 2 to 3 months that people will be taking as a result of being selected from the H1B lottery.
Okay. It's going to be very busy for folks out there for the next 2, 3 months for sure. And
Yeah.
Prashant, we have viewers out there already dropping in questions on YouTube. I'll just say hi to all of them. And Himmat, Samira, China Reddy. Well, okay, let's take up China Reddy's question. H1B holders within 60 day of layoff, if they can't find a job, can they go back to H4 or F1, L2? Basically, their previous status.
Yeah, no. So, um, if this individual is facing a layoff, I'm sorry to hear that. I'm seeing more and more clients, especially from the tech sector, approaching me for consultations around this, scenario, this situation where, they are getting laid off. And yes, you do have a 60-day grace period, but if you're not able to find another job, and let's say you have a spouse who's also on an H1B, you can change status back to H4. Or if you have a spouse on L1, you can change your status to L2, right? So doing a change of status within that grace period time, right? Where you're unable to find a job is absolutely viable, right? As long as you qualify for it. So you obviously can't get an H4 unless you have an H1B spouse, right? You can't get an L2 unless you have an L1A or L1B spouse. So those are all viable options. I've also had clients explore situations where, maybe they're the sole H1B spouse, in their household, and they're thinking about changing status to that of a visitor, right? You might have a mortgage, your kids might be in school, right? Those are scenarios that we see all the time, and it's very difficult to just leave the country because you lost your job and you can't find one within 60 days. So I have seen clients successfully opt for a B2 visitor status just so they can, buy themselves additional time to maybe wind things up in the US or even use that time to find another job and go back on H1B. So that those are options that are available out there.
Thank you for taking that up. Thank you, China Reddy, as well. And w- a big hello to all you folks out there, to Isik Davis, Anita, Pavan Kumar. We'll just take up Anita's question on Facebook. This one is each and everyone notified about the selection?
So by each and every one, I would say the petitioner is notified, right, as well as the petitioner's attorney, if they have used or leveraged an attorney for the registration. The beneficiary is not notified, right? So the beneficiary does not get an email saying whether they have been selected or not. That is information that is only available to the petitioner and in the petitioner's online US account. So they can go to their online account, they can look at the dashboard of registrations, and if you're selected, it'll say selected. Now, don't lose hope if you haven't been selected because there usually is a round two of this H1B lottery, right? Typically
Mhm.
around the July to August timeframe, where you'll notice that folks will be notified, petitioners will be notified that people that weren't initially selected did in fact get selected, right? And that happens because USCIS doesn't always get the exact number of H1B applications to fill their annual cap. Um, so that's how the selection process would work.
Thank you, Prashant, for taking that up. And Anita, I hope your question is more clear now. And Prashant, since we're talking about the process, how does the process following the lottery vary between those who are selected and those who are not, especially for the H1B visas, the current
Yeah,
lottery?
yeah. So if you're selected, right, great, you get to go into the next round of the Hunger Games. But you basically move to that next stage, where your employer is going to start collecting documents from you. They're going to file the LCA for you. They're going to assemble the I-129 application package, and send it off to USCIS. For those that are not, right, you will either have to wait for the second round, right, of the lottery, or even potentially wait another year to enter your name again into the lottery, right? So there's no limit on the number of times your name can go in, right? You can apply annually. I've had clients who've, applied 4 years in a row, never got selected, right? And that is what it is. It's a great kind of equalizer in that sense. In terms of individuals that might already be in the US, right? So let's say you weren't selected and you're on F1 status, and you're working on your OPT, your STEM OPT, your STEM OPT extension, whatever it would be. You can continue to work on it, right? Just because you weren't selected in the lottery doesn't mean that your current status gets invalidated. Um, I've had clients who are on H4, working on H4 EAD. They try to go into the H1B lottery. They don't get selected. Completely fine. You continue working on your H4 EAD. Um, so for some folks that are already here in another status, right, you continue on. For others that might be in India, still trying to break into the H1B sort of system, you try your luck again next.
Okay. So there's no need to lose hope. I mean, we can always keep trying. And folks out there, it's very important to stay optimistic. So I'd say all the best. Let's stay hopeful throughout the weekend and also for the next selection process. Also, let's just keep our fingers crossed for now. All right. So Prashant, I mean, could you even offer some advice on how to effectively handle the request for evidence, the RFE phase for H1B applications? That's going to come up right
Yeah.
now, right?
Yeah. So RFEs, kind of getting a request for evidence, a lot of people get concerned about it. A lot of individuals are very scared about it, right? And you want to think about it in very specific categories. The most common RFE that I've seen is specialty occupation, right? Especially over the last few years. USCIS loves issuing an RFE to ask you the job responsibilities that you've described to me, do they actually fall within a specialty occupation? Which essentially means, does it require at least a bachelor's degree, right, in a specific field of study? Are the position responsibilities so complex that it would require at least a bachelor's degree, right? And so when one is preparing an H1B application, it's important to analyze the details of that offered position, right? Identify the red flags, and really, for me, suggesting ways to address improvements, to the job duties, right? And so sometimes I'll have individuals that'll come to me, or employers that'll come to me, and the job duties are not very granular in nature. It's very high level, right? For example, developing applications, software, developing web applications, great. But like, what are those web applications? What are the tasks involved in doing that development work? What are the specific programming languages that are going to be involved, right? So it's very important to be able to get as granular as possible in the job duties and the job responsibilities so that you can say, hey, based on the Bureau of Labor Statistics and their occupational outlook handbook, these job responsibilities match up to those of a software developer, right? Um, and if you get an RFE, again, it's not the end of the world, right? Maybe you didn't do the right analysis. Maybe you didn't have the correct data from the Bureau of Labor Statistics, or the ONET handbook. That's okay. You can go back and do that analysis and provide them with those details. And what we typically send along in that initial filing is what's called a specialty occupation and beneficiary qualification letter, right? Which describes the job duties, explains how it's relevant to that of an information security engineer or a business analyst or a software developer. and how those responsibilities line up to that which is on ONET or BLS, and then how the beneficiary has the qualifications, right? Maybe they have a computer science degree, that shows that they can do this specialty occupation, right? And so if you feel like the analysis is not enough, one thing that we've leveraged pretty effectively is expert evaluation letters, right? So if after providing that level of detail in the initial application, you can always go back and provide what's called an expert evaluation letter, right? There are agencies that work with professors out in the industry, right? Who have done research, who are considered experts in their field, that will say, yes, these job responsibilities are so complex, are so unique that it does in fact require a bachelor's degree. And this person has the bachelor's degree or has the education to actually do it, right? Another one that we always see, in terms of an RFE, can be for beneficiary qualification. This tends to pop up if, let's say, a software developer role is being offered to somebody that might have an electrical engineering or mechanical engineering degree, right? So USCIS, like their mind gets blown when they see that because they're like, well, it's not a one-to-one match, right? Like it's not a computer science degree, but keep in mind, that their coursework does include programming languages, right? And I'm sure at some point in their work experience, there is software development work experience or web application development work experience in there that can translate into qualifications for this specialty occupation, right? Again, an expert evaluation letter can help you there. Another category of RFEs that can sometimes arise is with regards to the wage level, right? So sometimes you will say, "Hey, I need somebody that has 10 plus years of experience, with this specific, skill set or this specific job," but they're only paying them a level one wage, right? And so that sort of mismatch for USCIS doesn't add up because to them they're saying you're essentially being unfair to this person based on their experience. Maybe they have a master's degree. This person should at least be a level two or a level three, right? Level one is for entry level, level two is for mid-career, right? Level three might be mid-career plus master's degree, so you have to pay people the right wages to avoid any scrutiny from USCIS. And then I would say another one that I've sometimes seen is, USCIS will issue this. This is especially in the case for startups. USCIS will sometimes issue an RFE, if they don't have enough details about the employer. So recently, I saw one where they said, "Hey, we have this system. It's called Vibe. That is where we go in and verify all of the employer details, and we simply cannot verify your employer details, right? We don't understand where you're headquartered, and so they give you specific set of directions, where you can go and update that information. You can provide a printout of everything you've updated, respond back to the RFE accordingly. So I would say those are really the top four, that I tend to see, with a heavy kind of focus on specialty occupation, beneficiary qualification, and that wage level piece. But that's also how I would suggest to handle all of these things.
Right. So RFEs are nothing to be worried about, friends. All you need to do is just give more proof to prove what you stated in your H1B application. So, all right. So, Prashant, let's take up a few more questions from folks out there since we have quite some of them. So, let's go with Himmat. Is there any notification if I'm not selected for H1B? How can I know I am not selected?
Yeah. So it's funny because until USCIS kind of fully does this lottery selection process, and I'm saying even post second lottery, they don't
Mhm.
notify anybody that they've been not selected. So your status is going to stay in a submitted status until they conclude it for this fiscal year 2025, essentially. And so it's unfortunate because you're kind of left hanging in some instances where people that have been selected, their status gets updated to selected. People that don't get selected, it just says submitted. And then when USCIS decides, we've concluded our registrations for fiscal year 2025, that is when you go into not selected status. So that could happen 4 months from now, 5 months from now, or even 6 months from now, right? Um, so if you don't hear back from your petitioner, your employer or the employer's attorney that you've been selected, by April 1st, let's say, then it's safe to assume you haven't been selected in this initial round.
Okay. All right. So Himmat, you'll just have to hang on. It'll be a suspense for now, at least. All right. So moving on, let's take Samira's one as well. This one is, what should applicants do if they receive a? Okay, I think this one we just took it
Yeah.
up. So Samira, I hope you got your answer. All right, then Essex Davis, I got RFE for I140 in premium processing, something that could happen a lot, or there is less chances in premium.
Yeah. So it depends on, the I-140 application that was filed, right? If it was EB1A, they could challenge you for a number of things, right? There's 3 out of 10 criteria you need to meet. Maybe they want additional evidence or exhibits on one of those criteria. If this was EB2 or EB3, some of the common reasons for I-140 RFEs in EB2 or EB3 can be related to, does this person qualify for the job that they're being sponsored for, right? Um, does the employer have the ability to pay their wages? So it just kind of depends on what's in the RFE letter. But yes, it does happen. You will just simply have to work with your employer's attorney to respond back to what's specifically in the RFE. But yeah, it's totally possible. It just depends on what they're looking for. Maybe they're trying to understand, where did you obtain all of this work experience from? If you didn't submit experience letters as a part of the I-140 application package, right? Um, we've actually done a few webinars on the I-140 process if you want to watch those on YouTube. But if you didn't submit experience letters, USCIS is going to wonder, this job that you're being sponsored for, where did you get the skill sets, right? So maybe it's related to that.
Have done webinars on I-140. I mean, if you have the time, go check them out. They are under this channel, Immigration and Jobs Talk Shows. So, and let's take up a few more, and then we'll go for a short break. I think, Prashant, if that's fine with you. Let's
Sure.
take up Ishan. He's asking, I have a question about the RFE. The students who have got the RFE or OPT application, will they get RFE for any other future application? For example, like when they file for STEM OPT or H1B.
I mean, it depends on what the RFE was for OPT, right? So, for example, really hot topic in the immigration world right now is folks that were employed with Apex IT systems. So when you submit an application for an OPT EAD, you also need to submit your I-20s, right? And in those I-20s, if you've got Apex IT systems in there and you got issued an RFE for it, chances are you'll probably be hit with another RFE in the future for STEM OPT or H1B as well, right? Because USCIS is scrutinizing that employment very carefully. If you got
Mhm.
an RFE because you forgot to submit 2 passport style photographs for your OPT application, and you correct that mistake in the future, you provide the documentation that was required in the future, you have no issues, right? So it just depends on the nature of the RFE, what they were looking for, if there's any fraud, anything like that in your background, initially for purposes of the OPT, that could always come up. But if it was a
Mhm.
simple clerical thing where you maybe missed a document or two, um, chances are you probably won't be issued an RFE if you provide all the right documentation.
Okay. Thank you for taking that up, Prashant. And um, I think we should go for a short break for now. But folks out there, I know you have a lot of questions, so I will just say stay with us. And also, if you have questions directly to the attorney, don't forget to email him. His information is displayed on the screen. Info@dubeylawoffice.com. That is Prashant Dubey for you, friends. And Absolutely. We will talk more with him about mastering the post lottery H1B process. And I can see so many questions. So I'll just say stay with us. We are going to take them up very, very soon. But now let's just go for a short break and we'll be right back.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833 412 8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everybody, and welcome back once again to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and I hope you had a refreshing break. I know it was a very short one, but thank you for staying with us. So, yes, I hope you're ready to continue our discussion today on mastering the post-lottery H1B process, and we're getting expert insights and guidance from none other than our esteemed guest today, again, immigration attorney Prashant Dubey from Washington, D.C. Really great to have you back, and I hope, Prashant, you're having a good time with us today. Oh,
Ah,
wait.
thank you, Zion. No, it's always a good time. And what's even better today is I'm able to join on my computer. So I don't have to get on my phone because I'm having technical difficulties. For some reason, it just works today. So it's perfect.
I know, right? Well, I'm glad it's working. And friends, thank you for your questions. Stay with us. We will continue our discussion with Prashant today. And Prashant, maybe if you could discuss with us, what are the frequent causes of rejection for H1B applications, and maybe what steps can be taken to overcome to avoid these kinds of issues?
Yeah, so I would say, some of the frequent causes of rejection are also similar to the reasons why people get an RFE in the first place, right? Maybe you weren't able to convince USCIS that the job is a specialty occupation, which means that it requires at least a bachelor's degree, or the position is so complex, so unique that it requires a bachelor's degree, or that a bachelor's degree is common to the industry, right? For the position and for the job duties. Um, Other times it can be for beneficiaries qualification, right? Maybe they just simply don't have the underlying coursework or the underlying work experience that will satisfy the requirements of the job. I think those two things can be fairly, if you get an RFE for it, you can avoid a rejection by getting an expert evaluation letter done. And that's something I do kind of as a best practice with my clients, where sometimes it's funny because I'll give you an example. I had a client where we applied for two computer systems analysts. They essentially had the same degrees, it's the same job responsibilities. One of them just got approved. One of them ended up getting an RFE, right? And so for the one that got approved, he went on, did his visa stamping, everything was fine. The one that got an RFE, I suggested, hey, let's go get an expert evaluation done, right? Like, why take the chance of, giving a USCIS officer the opportunity to reject an application? And so we got an expert evaluation done, and lo and behold, he ended up getting approved, right? But that is to say, these USCIS officers can be very subjective in nature. They can take a look at the same job responsibilities, the same SOC code, essentially the same work experience and education documents, and say, hey, look, for this guy, we don't want to ask you anything and we're going to approve it. And for this guy, we're concerned about whether or not this is a specialty occupation. And we're like, well, that's inconsistent, but what can you do? Um, Another reason why you can sometimes see rejections is because, again, the wage levels just don't add up, right? You're trying to pay someone a level one wage. but they have 10 years work experience plus a master's degree, or you're requiring 10 years of work experience, but you're only going to pay them a level one wage, right? That can be a challenging situation. And another one that I think sometimes escapes people, or it's not always talked about, is if you travel, right? So if you have, let's say, a change of status application from H4 to H1B or F1 to H1B pending, and you decide to travel during that change of status period, that can also result in a rejection, right? Or potentially require you to do consular processing. So that's something I always tell people to be very careful of. If you can avoid travel, please do so. Otherwise, you could potentially be facing a rejection or having to deal with the consular processing, which means go fill out a DS-160 application, go get your visa stamped, go in front of a visa officer, which also means you've now increased your chances of being put in 221G processing, potentially, right? Just because you never know. I've seen people with very clean immigration records be put into 221G processing for no reasons. So those are some of the common reasons for rejection. But they again tend to concentrate a lot around the specialty occupation and beneficiary qualification.
Okay. Okay. Thank you so much for taking that up, Prashant. And I mean, we'll definitely take more questions. And Ramesh, by the way, on YouTube is asking, when will the results be completely out?
Yeah, so USCIS, I don't know if people follow them on X or Twitter, but they posted that they're going to be releasing the lottery selections over the next few days, and they should all be rolled out by April 1st. So I would say, probably by the end of this month, the next 2 or 3 days, everyone should know uh, about the selections.
Thank you. Thank you, Prashant. And this one is from Shoaib. Shoaib is asking, is selection in lottery purely luck based?
It is. I mean, unless you've done a U.S. master's degree, then that increases your chances just a little bit. But that's why it's called a lottery, right? It is kind of purely based on luck. If your name gets selected, then you get to move forward. If it's not, then you have to wait.
Okay. Well, there's a follow-up from Shoaib on YouTube asking, if someone didn't get selected for last 6 years, does it affect positively or negatively in terms of selection? And if selected now, are post activities any different from them?
No, right? So it's not your fault that you didn't get selected, right? There's no fraud, misrepresentation, anything like that happening on your part. It just means the computer algorithm didn't pick you out, right? And again, that's not your fault. If you do get selected now, which I hope you do, right? Lucky number 7. If you do get selected now, there's nothing different that you would have to do, right? You have to follow the same exact process as anybody else that gets selected in the H1B lottery.
Okay. Shoaib, I hope you have your doubts clarified now. If you have more questions, you can keep posting. And well, China Reddy also has a follow-up asking, what if someone's job doesn't start until February 2025 or got project start got delayed until February or March? What then?
Yeah. So that's okay, right? It kind of depends on where you are, um, or what you're doing. So let's say you're in India and your H1B gets selected and it has an effective date of October 1st, let's say 2024. In order to activate your H1B, if you have to do it in consular processing, you're going to have to go get a visa stamp, right? So in the meantime, you can at least go get your visa stamps, right? Um, and during that period, you don't travel, right, until the project actually starts. Because once you're in the country, you have to start working. Payroll needs to be run. You can't be put on the bench, right? So you can maybe wait to travel on your visa stamp until your project is actually going into effect. Now, let's say you're here in the US and you're doing a change of status, and your change of status, goes into effect on October 1st, for example. Um, if your employer doesn't have a project for you, that's going to be an issue, right? Because again, they can't keep you on the bench. They have to run payroll for you. They have to essentially employ you, right? And you need to be creating work product during that time. So you can always think about, the effective date, and this is something you work out with your employer. You can think about the effective date being March or February or March 2025, right? So that change of status won't go into effect until next year, let's say around this time, right? That way, you're not going to be violating your H1B. So you'll still have all the benefits of being selected from the H1B lottery, but the effective date can just be a few months out into the future so that, again, you're not violating your H1B status.
Thank you for taking that up, Prashant. And well, Tina, keep posting, I would say. And Prashant, we are also like in the post lottery period already, you can say. And what is the responsibility of employers in assisting their H1B candidates?
Yeah, so they have, you know, quite a bit of responsibility for this, right? And the reason is because it starts with working with the attorney to first collect all the documents, right? So you're going to have to get documents from the beneficiary, passport, I-94 record if they're within the US. You're going to have to get their education documents. If they don't have an education evaluation, you need to help, support them through that. You need to get their resume, right? So once you have all of that, you then need to create the job offer, or maybe you've already sent them the job offer. You need to understand what the job duties are going to be, and you need to outline that. From there, you're going to give all of that paperwork to the attorney. The attorney is going to file the labor condition application, or the employer is going to file the labor condition application, and you're going to submit all of that paperwork, signing the LCA, signing the 907 if you're doing premium processing, signing the I-129, paying for the associated application fees, right? Now, keep in mind, premium processing is a fee that can be offloaded to the beneficiary. So if you opt for premium processing, the employer is not responsible for paying that. If they choose to, because they're extending a good faith effort towards you, that's perfectly fine, but they're not responsible for it. And the beneficiary will take, responsibility for their own documents, as I mentioned. But it is the responsibility of the employer to see this entire process through, right? Their name, their signature is what is going on the LCA and all of the applications.
Okay, thank you, Prashant, for taking that up. And well, let's move on. I have one more thing. And how do current immigration policies and the overall environment impact the H1B process after the lottery?
Yeah. So, I would say, some of the new policies that are potentially coming down the pipeline, right, relates to specialty occupation, right? This is something that
Yes.
tends to come up a lot within the H1B application just because it's such a critical component of getting an H1B approval. And so USCIS is looking at revisions to how the specialty occupation is defined, right? So in the past, right, or really up until now, and maybe even for the next few months, um, employers have been able to sponsor individuals, from degrees and work experiences and backgrounds that might not be directly related, to the role, right? So, for example, you could have a software developer with an electrical engineering or mechanical engineering education background, and they could still qualify, right? USCIS is trying to tighten that up now a little bit by saying, no, it needs to be directly related to the field, which means if you don't have a computer science degree, or if you're not able to prove it by way of experience, um, you're not going to qualify, uh, for the specialty occupation. So that's something to keep in mind. And then another revision that they're trying to make is sometimes USCIS officers will think the only way that a specialty occupation or that a job will qualify as a specialty occupation is if it always requires a bachelor's degree. And they're trying to get them to move away from that mindset and say, hey, if more than 50% of the time in the industry, right? And you can pull these statistics from websites like careeronestop.org or the Bureau of Labor Statistics. If it's more than 50% of the time, if, it requires a bachelor's degree, that will still qualify as a specialty occupation. They don't always need to have a bachelor's degree. It just needs to be more often than not, more than 50% of the time, at least as I'm interpreting it, right? So these revisions, they're not implemented yet, but they are things that USCIS is considering to kind of overhaul the definition of specialty occupation.
Okay, I mean, especially because I think experiences also count, and nowadays folks out there are also very differently abled in their own way because they are some are like tech geeks, some are very tech savvy, and everybody has so much knowledge. I would say, they're self-teaching themselves as well, right, Prashant?
Right. Absolutely. I mean, certifications. People
Right.
get, people might have a bachelor's degree in an area that's non-technical, but then they've got the work experience, they've got certifications that they've done that are very technical in nature, right?
Hmm.
You've got people who do MBAs, with a concentration in some form of a technical domain, but the way if USCIS goes in this direction, it will be very difficult for those people to prove that my coursework is directly related to it, right? Because you've only done a subset of that coursework. Your entire degree program wasn't dedicated to the field. So I think it's going to become a very strict reading if this actually gets implemented.
Okay. Okay. All right. Let's take up a few more from the viewers out there. Let's take this one from Instagram. Wow, we have one in Instagram now. So we are streaming live on Instagram as well. Thank you to folks out there on Instagram. This one is from Rohan Shah 1423. Rohan is asking, I am an Indian citizen and can I apply for an EB3 visa, and how long is the processing time?
Yeah, yeah. So EB3, right, is if you're in, let's say you're probably in India right now. You can apply for the EB3. It will require an employer sponsor, right? So it's a conversation that needs to start with your employer because you need a petitioner who's going to file your prevailing wage determination, file your perm labor certification, and then eventually file your I-140 application. Once all of that is done, essentially you're waiting for your priority date to become current. And the priority date is based on the date you filed your perm application. Right now, EB2 and EB3 priority dates are in 2012. So let's say you get a priority date, maybe the earliest you're going to get is late 2024, maybe early 2025, depending on how quickly your employer moves. Until that priority date doesn't become current, you will not get an employment-based green card, right? So if you're looking for a visa, right, if you're doing this from abroad, um, you could be looking at a decades-long process from filing your PWD to getting eligible to get a green card, right? Until your priority date is current. Even if you're within the US, you're looking at the same timeline. So you're waiting for that priority date to become current before you're even eligible to apply for the green card.
Okay. Thank you. Thank you, Rohan, for that question. And let's move on to another one. This one is from Instagram again. We took this one already. Yes. Yohini is asking on YouTube, I am H1B visa with an approved I-140 for an EB3 green card. I am changing to a new employer who is applying for an H1B transfer. Am I eligible for unlimited renewals for my H1B with the new employer?
Yeah. Or any future employer for that matter, right? Because you have an approved I-140 on file, you can
Mm.
extend or renew your H1B beyond that 6-year max out kind of indefinitely, right? Until your priority date becomes current. So whether you want to do that with this employer or whether you want to do another H1B transfer in the future, um, that's absolutely fine. You can do that. You can continue to renew. Just keep in mind, though, when your priority date does become current, that employer you're working with will need an I-140 application on file for you, right? Or you'll need to talk to that original employer that sponsored your I-140. And as long as they're willing to offer you that same job that you were sponsored for, then you can apply for your green card. So that's just the only nuance, right? Sometimes people forget that, you know, every time I do an H1B transfer, you also need to kind of figure out the timing of when your priority date's going to become current because otherwise, your current employer won't be able to sponsor you, or sorry, sponsor is not the wrong word, not the right word. They won't be able to support you for the 485 application with what's called a supplement J. And that supplement J form basically says, we have a job for this person once they get their green card. And that's a very important document, right? So just keep that in mind.
Chance for that. And yes, so we will go to Pavan's question. This one is on YouTube. If beneficiary filed multiple registrations, will beneficiary know all multiple registration selection notices?
So essentially, what USCIS did this year was say, hey, we've had a lot of fraud in our system over the last 2 or 3 years because of multiple registration filings, right? Um, and essentially, as a result of that, people were increasing their chances. They were getting 10, 20, 30 different employers, sometimes employers that, were related companies filing for them to increase their chances. What USCIS did this year was, hey, you can have multiple unrelated employers file for you, but we're only going to select you based on your passport number, right? So they kind of flipped the script a little bit and said, because a passport number is unique, only the selection is only going to be based on a person's passport number and that unique identifier. So if you've had 10 different employers file registrations for you, that's okay. Once you get selected, you can decide which one of those 10 do I want to have file my I-129 application for me. But it doesn't mean that you've got 10 different chances anymore, right? So whether you get selected or not, the petitioners will get notified. All of the petitioners will get notified, but then it's up to you as to which one you want to move forward with.
Oh, that's very interesting. So, I mean, the beneficiaries have the choice for that. But then, of course, they just have one chance, even if they have applied in 10 different,
Yeah.
for 10 different employers. Yeah. All right, let's take this one up from Jolty. How does the cap gap extension work for F1 students who were not selected in the H1B lottery?
It doesn't work. That's the problem, right? So you only get the cap gap extension if you're selected, right? So basically, what the cap gap extension is an individual who's on F1. They might be working on their STEM OPT extension, and their STEM OPT extension expires, for example, on August 1st, right? So what do they do between August 1st and October 1st when the H1B status is going to go into effect? And so what USCIS created was this cap gap extension rule saying you're not going to go out of status. You can continue working during that time, but in the H1B application, you need to state very explicitly that this is a cap gap extension application, right? And therefore, you can work even after your EAD card expires while you're on F1, and then you pick right back up on working on H1B effective October 1st. If your H1B lottery registration is not selected, there's no cap gap extension because there's no H1B application. So if your EAD card expires on August 1st, then that's kind of the end of the road for you on F1 status, right? Then you need to figure out, do I change status to something else? Maybe you have a spouse who's on H1B and you try to go to H4, Maybe you have a spouse who's also an F1 and you try to go to F2, right? So those sorts of options could be available for you. But if you're a single individual and you didn't get selected, you know, you either you leave the country or you transfer your SEVIS record to another. And I've seen people do this. You transfer your SEVIS record to another school, right? You continue studying, continue taking cracks at that H1B lottery, right? That's also an expensive decision to make because, as you just heard here, people try 6 times and they still don't get it, right? So, just things to consider.
Let's take up Baldeep Singh's questions. He has two. So, asking if an H1B cap subject petition is filed based on a selected registration notice, but the petitioner fails to establish eligibility for the petition approval based on existing statutory and regular regulatory requirements, what is the outcome, and can the petitioner refile the petition?
Yeah, yeah. So it depends on when it's done, right? So this is kind of an important piece of this puzzle. Try to file the H1B application as quickly as possible. Don't wait until June 30th. Don't wait until the last week of June, right? And the reason why I say that is because if you, let's say you do this in premium processing, you're going to get a decision in 15 days. And let's say that decision is a rejection, right? Let's say you apply on April 15th, you know by end of April that your application's gotten rejected. The petitioner can refile the application until June 30th, right? So you have the ability to refile that application. But let's say you get your rejection after June 30th, you're stuck in an I-290B type of a situation where you're going to be filing a motion to appeal USCIS's decision. So you lose the ability to simply refile the application. So I would say, if you're concerned about that, definitely get ahead in terms of the timeline to file the application as soon as possible. In case you do get a rejection, you can just refile.
Okay. That is good news then, I think, for both Deep. Now let's take this one up from Safura. Is it recommended for someone on F1 OPT or CPT to go for a change of status visa stamping if their H1 is approved?
Um, so see, that's a conflicting statement, right? And maybe because I'm working within the technical nuances. Um, Change of status is different than visa stamping, right? Change of status is you stay within the U.S. and you're applying F1 to H1B, and you don't need to go for a visa stamping when that happens, right? Your H1B kicks in and activates on October 1st of this year. Consular processing, which is the visa stamping, is when you decide, hey, look, I'm not going to do a change of status, and you have to very specifically outline this. There's a question in the I-129 application that asks, is this a change of status or is this a consular processing application? So you need to work very closely with your employer to identify what it is you want to do, right? If you want to do consular processing because you've got some commitments, you got to go back to your home country, you can opt for that. So when your F1 status runs out, or when whatever status you're on currently runs out, you can activate your H1B from abroad, right, from your home country, and you can get a visa stamp. So I would say, it just depends on your situation. Most clients that I know that are here in the US, they always opt for change of status, right? The less you have to be in front of a visa officer is kind of the approach that they take. Now, if you're already in India, you don't have a choice, or if you're already in your home country, you don't have a choice. Consular processing is the only thing available to you. But I'd say 9 times out of 10, if you're in the US, it's usually a change of status that I see my clients opt for.
Okay, thank you, thank you. And we'll just take up the last question of the day from the audience, and that is from Krishna on YouTube, asking what is the consequence of filing an H1B cap subject petition without a valid selected registration notice? And what is the time frame for filing an appeal if the petition is denied or revoked?
I mean, I don't think an employer is even going to do that, right? Why are they going to pay USCIS the application fees, the fraud detection fees, the American Competitive Workforce Act fee if you haven't been selected, right? There's a section of the I-129 application that asks for your lottery selection registration number. You have to fill that out. You have to submit the selection notice with the application, right, as the initial piece of evidence. I don't know any attorney or any employer that would go down that rabbit hole only to then get a rejection, right? So um, there's nothing to appeal because you didn't get selected. So you need a selection, you need a registration notice. Um, Otherwise, USCIS is just going to outright reject the application. And you're going to lose all your money. That's all that's going to happen.
Right. Right, Prashant, thank you so much. And folks out there, that wraps up today's live webinar on Immigration and Jobs Talk Show on the topic Mastering the Post-Lottery H1B Process, Expert Insights and Guidance. And I would really say a big thank you to you, Prashant Dubey, for joining us here, and for sharing your invaluable expertise and insights with us and making this whole webinar a very informative one today. Thank you so much.
Yeah, no, I appreciate it. It was great. I think we interacted with the audience more this time, which I enjoyed, right? It's always good to go toe to toe with folks, answer their questions. Because these are the practical things that folks are thinking about, and it is such a complex, convoluted process that I really enjoyed shedding whatever light I could, right? So thank you to the audience for being so engaged. Thank you to you, Nipa, for hosting. Zayed, thank you for all the crowd control you're doing in the background. One day we'll get you on camera. And thanks to Higher IT again for hosting me.
Thank you, Prashant. It's always an honor, and I'm already hoping to see you again next week. Hopefully, you won't get too busy, and I hope that, with folks out there who are already excited and who could make this webinar also a successful one by joining us. Thank you to all you folks, and thank you so much, Prashant. Have a great day ahead, a great Friday, and a happy weekend to you, Prashant.
You too. Thank you.
Thank you. And thank you, viewers, once again, wherever you joined us from, whether on Twitter, which is X, or Instagram, Facebook, LinkedIn, YouTube. You folks are great. Thank you for making this webinar a successful one. And keep posting your comments. We will try to reply and get answers to your doubts and clarifications for sure. So I really want to say thank you once again. And your active participation and engagement has made this webinar a more interesting one, I would say. So before signing off, I would just say and remind you folks to maybe subscribe, not maybe, please subscribe and like, share. And yes, don't forget to hit the bell icon because there's another webinar coming up in probably an hour. Yes, in an hour at 2 p.m. This is with our host Rajni Parara, and we're going to have a guest Yvette Bansal. So it's going to be a good one for you folks out there. So stay tuned with us, and thank you once again for making today's webinar a good one. And stay tuned with us. This is Nipasa Pradhan signing off for now from Immigration and Jobs Talk Show.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.